Our next case is People versus Pinson. This is a 15-minute mini oral argument on the application. Good morning. You may reserve time for rebuttal, but we ask that you keep track of your own time. Thank you.
It's already as low as it'll go. All right. Good morning, Chief Justice, Your Honors, and may it please the Court. Angeles Meneses from the State Appellate Defender Office, and I, along with co-counsel Dominica Convertino, represent Armond Pinson. MCL 769.8 only mandates an indeterminate prison sentence when one is imposed. It does not require a prison sentence for all first-time felonies. To hold that it does would contradict the plain language of the statute itself and its legislative history, as well as Michigan sentencing jurisprudence, and implicate grave public policy concerns. I'm open to the Court's questions at any time. First, Your Honors, if we look to the plain language of the statute, MCL 769.8 only mandates an indeterminate sentence when a prison sentence is imposed. It does not require a prison sentence for all first-time felonies. The language of the statute itself says, quote, where the sentence may be prison. Therefore, prison is a sentencing option in such instances, but it is not the only option available. The section also provides for exceptions when it says, as otherwise provided in this chapter. And so that's to accommodate, for example, determinate prison sentences such as life without parole for first-degree murder or parolable life. Also, Your Honors, if we look to the legislative history of the statute, this statute was first created in 1902 and then was revised in 1905. And this court actually found in Forscutt that both the old statute and the revised statute, which has language that mirrors the current statute, had the same general purposes and intended for indeterminate sentences to be a punishment for a crime.
Can I ask you a foundational question? Is this appeal about how defendant's sentence range was calculated or about the trial judge's decision to depart downward from that guideline range?
It is about whether the trial judge had a valid reason for departure and whether that sentence is valid, Your Honor. So again, and also statutes that were on the books at the time of both the creation of this statute and to this day allow for either jail or prison to be alternative sentences for certain offenses. For example, desertion, attempt to commit a crime, failure to stop at the scene of an accident, et cetera, et cetera. All those statutes are examples of ones that provide options of jail or prison to be sentences imposed for felonies, even first-time felonies. We must also read MCL 769.8 in pari materia with the Code of Criminal Procedure, which it is a part of, and that includes sentencing guidelines and offense classes. When you read those together, it's clear that the legislature meant to provide for different types of sentences, depending on the severity and the individual circumstances of a case. And to create a blanket rule that requires an indeterminate sentence for all first-time felonies would contradict this. The legislature intended for the guidelines to apply to most felonies and also created crime classes to reflect whether an offense is more or less serious than another and which guidelines grid can be used to determine an appropriate minimum sentence. A sentence recommendation could be an intermediate sanction, it could be a straddle cell, it could be a prison cell. Crime classes also dictate the max term of imprisonment for each felony offense. Moreover, in 769.34, departures from the guidelines are permitted, such as what was exercised here. Judge Hulsing did sentence Mr. Pinson to a downward departure from his guidelines, and the question is whether that was an invalid sentence. However, Judge Hulsing was within his discretion to depart downward when sentencing Mr. Pinson, and he provided adequate reasoning for doing so on the record as required by the statute. The cases that are cited by the prosecution, which are People versus Frank and People versus Austin, are wrongly decided, and this goes towards the argument that Michigan sentencing jurisprudence supports the reading of the statute that prison is but one option for those who commit first-time felonies. Frank and Austin were wrongly decided and ignore Michigan jurisprudence holding that non-prison sentences are sentencing options for some felonies and individuals who have committed them. For example, People versus Haymond in the Court of Appeals and People versus Johnson both upheld a jail sentence as a valid sentence for a felony offense, even though the statute said it was punishable by up to 4 years in prison. Those cases have not been overturned. Also in People versus Kern, the Court of Appeals acknowledged that jail was a sentencing option for criminal sexual conduct in the second degree, which is very similar to Mr. Pinson's offense. And so even though the max punishment was 15 years, that individual got 5 years probation, and the court held that lifetime electronic monitoring was not validly imposed because it was a non-prison sentence. And that was actually highlighted in a footnote by this court in People versus Cole in 2012. Finally, Your Honors, it would have grave public policy concerns to impose a blanket rule that all first-time felonies require an indeterminate prison sentence. It would create a sentencing scheme that punishes people who commit first-time felonies more severely than others. For example, second habitual offenders. The second habitual offender statute does allow for the imposition of jail even when an offense is punishable by up to life. It would create essentially a mandatory minimum term, which trial judges would have to advise individuals of on the record, for example, if they were pleading guilty. And it would also curtail the trial court's discretion to impose individualized sentences, just as Judge Hulsing did here, depriving them of the ability to sentence to jail when the circumstances and the individual call for it. It would finally require a decrease in funding for jails and a substantial increase in funding for state prisons. Therefore, Your Honor, we would ask that you reverse the Court of Appeals opinion and reinstate Mr. Pinson's 6-month jail sentence as valid, and I will reserve my remaining time for rebuttal.
Thank you.
Good morning. My name is Joellen Haas, and I'm an assistant prosecutor in Ottawa County here on behalf of the people. Now, the issue in this case is about the guidelines and the circuit court judge not following the provisions of the indeterminate sentencing statute. When rendering a felony sentence, the circuit court, of course, has to consider the crime, they have to consider the guidelines, and they have to consider the law. In this particular case, we're dealing with the crime of a criminal sexual conduct in the third degree, which is a non-probationable offense. The guidelines for Mr. Pinson were 21 to 35 months with a maximum 15-year penalty. And what the law says is that he can't get probation based on the probation statute. He can't get intermediate sanction based on his high guidelines. And so then an indeterminate sentence within the guidelines is the only remaining available option absent a departure. And even if the circuit court could justify a departure in this case, which we don't believe it could, the sentence would still have to be indeterminate. It's not the people's position in this case, or any cases generally speaking, that all first-time felony offenders have to go to prison, in spite of how the question has been framed, and then, of course, the question that Your Honors have asked us to brief. In this case, the outcome in this case is the result of a unique set of facts. It's a non-probationary offense, and this defendant's guidelines are prison guidelines of 21 to 35. How he got to that level is that in OV3, he got the 14-year-old child victim pregnant, so he picked up 10 points. OV10, he had what I'm calling passed out sex with her. She was unconscious when she woke up to him having sex with her. There he picked up 5. And then finally in OV13, he not only had sex with her during the offense for which he was convicted, he had sex with her a couple of times subsequent to that, and that's where he picked up the 25 points on the OVs for 13. In the vast majority of cases, first-time felony offenders are not going to be precluded from receiving probation based on their charges, and their guidelines will not preclude them from receiving an intermediate sanction. They could get probation, they could get jail, they could get a combination of those. And this particular rule that's being discussed here, it's a fair rule, and it's fair because it allows each defendant to be sentenced based on their own circumstances. It's individualized. It does allow for the judge to use their discretion and depart if they so choose to do, but it also requires the circuit court judge to exercise that departure and that discretion within the confines of the law. And it also gives the victims and the public some reasonable expectation about what the outcome of the case will be. You know, the boots on the ground assistant prosecutors and defense attorneys dealing with criminal cases, whether it's from the lowest level felony offense up to very significant serious offenses, one of the first questions that's talked about is, what are the guidelines? What did you get? How'd you score these? So the guidelines are important. We recognize that they are advisory, but it's something upon which, again, as a practical matter, the parties involved are considering those. And so here, with Mr. Pinson, the people didn't, and yes, he's a first-time felony offender. Our position wasn't in the beginning, and it hasn't been all along, and it isn't today, that the reason that we took issue with this sentence is because he was a first-time felony offender and he has to go to prison. That wasn't it. The problem here is that we recognize that the statute allows for an intermediate sanction, and we recognize that the court had discretion to depart in this case where it's reasonable. You know, appellate counsel indicates that Judge Hulsing had put on the record significant or substantial or whatever you want, I can't remember what she said exactly, but sufficient reasons on the record for why he departed. That's a point that the people disagree with. All that's in the record on why he departed was because the defendant had some sort of an eye condition, a medical eye condition. I'm not demeaning that, but that's one of the reasons. And in this particular case, there was another sexual partner that this victim had who was in similar circumstances to the defendant in this case, yet that individual wasn't charged at all. My recollection of reading the information in this case is that's it. Those were the reasons for the departure, and we would argue, and did argue, that that's insufficient for the departure in this case. So in the final analysis, what the people are asking from the court is to affirm Judge Gleischer's decision in this case, which would require our circuit court judge to re-sentence the defendant, set the minimum and the maximum, the indeterminate sentence in this case, to be served in the Michigan Department of Corrections. That's what we were arguing down below in the circuit, and that's essentially what I had in the brief that I'd submitted, and that's what we're asking for again today.
And so presumably, the remedy you're seeking, it would get remanded, an indeterminate sentencing scheme would go into place, but then, of course, the judge at that point could choose to depart and follow the law with the reasons and put that on the record and all of that.
Right, right.
Okay, thank you.
Okay. All right, if there are any other questions? Thank you.
Thank you.
Thank you so much for your time.
Counsel, I'll just jump right in. So why isn't sort of the requested relief the prosecution's asking for correct? Why isn't it just, do you disagree that it should have been, I mean, I know this is sort of the crux, but should it have been, was the jail sentence alone a finite amount fine when it's, the Court of Appeals has said it should be indeterminate?
Yes, Your Honor. The Court of Appeals' opinion was wrongly decided in this case. A jail sentence was valid. And I understand, Ms. Haas's discussion of the facts of this case are well taken. I would disagree with the fact that Judge Hulsing did not provide reasons for the departure, besides those that were cited by Ms. Haas, that included Mr. Pinson's acceptance of guilt, the ages of Mr. Pinson and the complainant at the time, and the fact that there was another individual involved that was not charged but was also involved in this incident. And Judge Hulsing did take all that into account when imposing a valid 6-month jail sentence. But all of that kind of gets outside of what this court has asked us to look at, and what the remedy should be in terms of this court's question. It is whether MCL 769.8 requires a prison sentence for all first-time felonies, or whether this sentence was valid. And based on the interpretation of MCL 769.8, the Code of Criminal Procedure, of which it is a part, Michigan sentencing jurisprudence, and public policy concerns, this jail sentence was valid. There was no need for, the Court of Appeals opinion should be reversed. There was no need to have Mr. Pinson resentenced.
So the Court of Appeals, my understanding is they relied on, I'm looking at it, MCL 771.1, which specifically says that, probation, sort of lower things other than prison are available, except for, it says, other than murder, treason, criminal sexual conduct in the first or third degree. So that seems to be what the Court of Appeals hung its hat on.
That's correct. However, jail is significantly different from probation in that both jail and prison do require the individual to be supervised under, incarceration, whereas probation would allow somewhat more freedom than a jail or prison sentence. And so the definition of intermediate sanction at the time of Mr. Pinson's conviction and sentence did allow for jail as an intermediate sanction. I understand that that's been amended since 2021, but the lower court agreed that that's the definition that was applied here, given the statute in place at the time. And so while probation may not be an option in this instance, jail certainly was, and that is supported by the statutory language, the legislative history, and the case law. Frank and Austin, which were also cited by the Court of Appeals, again, were wrongly decided. Those disregard Michigan jurisprudence that acknowledge that jail is an option for certain felonies as a sentence.
Thank you.
Any other questions?
Just so I'm clear, he was given a jail sentence with no probation behind it?
That's correct.
Okay.
Thank you.
Thank you. Thank you both. The case will be submitted.